Welcome back to another deep dive. Today we are heading into the city. We're going to talk about that uneasy feeling you get when you walk through a dark apartment lobby late at night and the lock on the front door is busted. Again.
It's a universal feeling, unfortunately.
Yeah.
But legally, it opens up this massive can of worms.
It really does, because today we are looking at a battle that took place in Washington, D.C. in the late 1960s. It's a case that fundamentally changed the relationship between the people who own buildings and the people who live in them.
Oh, absolutely.
We're talking about Kline v. 1500 Massachusetts Avenue Apartment Corporation.
This is one of those watershed moments. It's the case that dragged landlord-tenant law, kicking and screaming from, the 19th century, into the reality of modern urban life.
And it's not just about broken locks, it's about a clash of two very different worlds. On one side, you have this ancient legal idea that a landlord is just a guy who rents you, dirt and four walls, and whatever happens to you inside those walls is your problem.
Right. The not my circus, not my monkeys defense, basically.
Yeah, exactly. And on the other side, you have the terrified reality of a tenant living in a massive complex surrounded by strangers, realizing they are a sitting duck in their own hallway.
And the question is, when a crime happens in that hallway, whose fault is it? Is it just the criminal? Or is the person who refused to fix the lock responsible too?
So before we get to the drama of the case itself, and trust me, the facts here are infuriating, we have to set the stage. Why was the law so protective of landlords for so long? Because my gut instinct says, if I pay you rent, you should keep me safe.
Your gut instinct is modern. The common law was, it was old. Traditionally, the starting point for the law was a hard no. A private person, and that includes a landlord, generally had absolutely no duty to protect another person from a criminal attack by a third party.
That sounds insane. If I run a business and I know it's dangerous, I'm off the hook.
For a long time, yes. And there were a few reasons for that, which, actually made some sense in a simpler time. First, the courts viewed a lease as just a transaction of land. You buy the right to use the space. The landlord isn't your guardian, they're just the vendor.
Okay, so it's like buying a used car. Once you drive it off the lot, if you get a flat tire, don't call the dealer.
A bit like that. But there was also a technical legal reason. It's all about causation. In the eyes of the old courts, a criminal act was considered a superseding cause.
Let's unpack that. Superseding cause.
Okay, so think of a chain of events. The landlord leaves the door unlocked. That's negligent. But then a criminal walks in and mugged someone. The court would say the criminal's choice to attack breaks the chain.
It breaks the chain of fault.
The criminal is an independent actor. You can't blame the landlord for what some madman, as they'd say, decides to do.
I see. So the criminal action just wipes the slate clean for the landlord.
Precisely. And finally, there was the public policy argument. Who is supposed to fight crime?
The police. The government. Not the guy who collects my rent check.
Exactly. The courts are terrified that if they made landlords liable for crime, they were essentially deputizing private citizens to be the police force. They thought that is the government's job, not the private sector's.
Okay, so that's the fortress of legal immunity that landlords sat behind for decades. Call the cops, don't sue me.
Right.
But then comes Sarah Kline.
Then comes Sarah Kline. And to understand why this case broke the mold, you have to understand the building. This wasn't some small duplex. We are talking about 1500 Massachusetts Avenue in D.C.
Paint the picture for us.
It's massive, 585 units. It's basically a small indoor town. And it had multiple entrances, 15th Street, 16th Street, Mass Ave. It's a complex ecosystem.
And when Sarah Kline moved in, this place was nice, right?
It was premium. This is crucial to the story. She moved in back in 1959. At that time, 1500 Mass Ave was a fortress. They had a doorman on duty 24 hours a day. They had a manned desk in the lobby where you had to check in. They even had someone watching the garage.
So she's paying for security. That's part of the...
Explicitly.
Yeah.
It's part of the rent. She chose this building because of that safety profile. But then, time passes. We get to 1966. The management changes, or they just start cutting costs.
The classic slow decline.
It was a free fall. By 1966, the doorman, gone. The desk in the lobby, unattended. The garage, totally unguarded. And worst of all, the side doors, those entrances on 15th and 16th Street, were frequently left unlocked all night long.
So it went from a fortress to a sieve.
Yes. And the inevitable happened. A crime wave started. And not just vague crime in the neighborhood. We're talking about assaults and robberies happening inside the building, in the hallways.
And the landlord knew.
Oh, they knew. Sarah Kline personally warned them. She went to them and said, "It is dangerous in these halls." Other tenants had been attacked. 2 months before the main event, another woman, Leona Sullivan, was attacked in the exact same hallway.
So the landlord is sitting there collecting the same rent as 1959, but providing none of the 1959 security, while tenants are literally getting mugged outside their doors.
Correct. And on November 17, 1966, at 10:15 p.m., it was Sarah Kline's turn. She was in the common hallway, just steps from her apartment door, when she was assaulted and robbed.
It's a nightmare scenario. You're home, but you're not safe. So she sues. And usually, based on what you told me about the old rules, the judge would just toss this out, right? Sorry, Sarah, call the cops.
And that is exactly what the lower court did. But then it went to the D.C. Circuit Court of Appeals. And this is where the deep dive really begins. The court looked at those old rules, no duty superseding cause, and said, this doesn't fit reality anymore.
Why? What changed in the eyes of the law?
They realized that the modern urban apartment building isn't just a piece of land. It's a service. And they developed a new theory of liability based on 3 big pillars. The first one is what they call the logic of control.
Control over what?
Control over the space. Think about it logically. If you live in apartment 402 and you're worried about the lobby door being broken, can you fix it?
I mean, no, I don't own the lobby. I can't hire a guy to change the locks on the front door of the complex. I'd probably get evicted for tampering with the property.
You have zero power. Now, can the police patrol the hallways?
Not really. They can't just walk into private property without a reason. They stay on the street.
So you have this no man's land. The tenant can't secure the hallway. The police can't patrol the hallway. Who's the only person on earth who has the legal right and the physical keys to secure that space?
The landlord.
The landlord. The court said duty has to follow power. If the landlord is the only party with the exclusive power to minimize the risk, then the landlord must have the duty to do it.
That makes total sense. If I'm the only one who can lock the door, I'm the one to blame if it's left open. What was the second pillar?
The second pillar was based on contract. This is the beat and switch argument we hinted at earlier.
Yeah.
The court said, look, a lease isn't just about space. It's a contract for a standard of living.
Because she moved in when there were doormen.
Right. The court said tenants are entitled to expect that the premises will remain in the condition they were in at the start of the lease. Sarah Kline signed up for a secure building. By 1966, the landlord had drastically reduced the security measures, but kept charging the same rent.
That feels like consumer protection. You can't sell me a Cadillac and then swap it out for a bicycle halfway through the loan.
Precisely. The court said the standard of care is measured by the protection provided when the tenancy began. You can't just degrade the service and shrug your shoulders.
Okay, so we have control. They had the keys. We have contract. They promised safety. What's the third pillar?
The third one is my favorite because it goes way back in history. The innkeeper analogy.
An innkeeper, like medieval taverns.
Yes. The court looked back at common law regarding inns. Even centuries ago, if you stayed at an inn, the innkeeper was liable if you got attacked by bandits inside the inn.
Why was that the rule back then?
Because travelers were vulnerable. They were in a strange place, relying entirely on the host for safety. The court in Kline looked at this massive 585-unit complex and said, in modern city life, this apartment building is the new inn. The tenant is just as vulnerable as the medieval traveler.
That is a fascinating connection. So they took this ancient rule and repurposed it for the 20th century.
They cleared away the legal underbrush, as they called it. They decided that an urban landlord owes a duty of reasonable care to protect tenants from predictable criminal acts.
Okay, I want to pause on the word predictable because that feels like the trapdoor. How do we define what is predictable?
This is the most critical part of the ruling.
Okay.
The legal term is foreseeability.
Let's test this. I want to throw a hypothetical at you.
Give me.
Let's say I'm a landlord. I own a nice building in a quiet town. Suddenly, a meteor crashes through the roof and hits a tenant. Or let's say a madman, someone completely unknown, never seen before, runs in off the street and attacks someone in the lobby. Am I liable?
Under the Kline analysis, no.
Why not? I control the building.
Because that is a mere possibility. The court was very careful to distinguish Kline from another case called Goldberg v. Housing Authority. In Goldberg, the crime was random. The court says everyone, everywhere, is subject to the risk of random crime. If landlords were liable for every random attack, they would need to be insurers of safety. They'd need private armies.
And the court doesn't want that.
No, that would be impossible.
Okay, so compare that to Sarah Kline's situation.
In Kline, we aren't talking about a random madman. We are talking about a specific hallway where robberies were happening repeatedly. The lights were out, the locks were broken, the landlord had been warned.
So it moves from possible to probable.
Exactly. That is the visceral difference. It's the sitting duck scenario. When the risk becomes probable and predictable and the landlord has notice of it, that is when the duty kicks in.
That distinction is huge. It's not about preventing all crime. It's about not ignoring a crime wave that is happening under your nose.
Right. The court explicitly said, the landlord is not an insurer. They don't guarantee you won't get hurt.
Yeah.
But they must take reasonable steps to minimize the risk.
So fixing the lock.
Fixing the lock.
Yeah.
Replacing the light bulb. Maybe hiring a guard if the contract implied it.
So let's bring this down to earth for our listeners. We have a lot of people who might be tenants or maybe even landlords or just people interested in how the law works. Let's make this practical. Let's do a proper feedback on Kline.
Good idea.
Okay, so let's analyze Kline. First, what are the legally dispositive facts?
Okay, the key facts. 1, a massive 505-unit building where the common areas, the lobbies, the hallways are under the landlord's exclusive control. 2, the timeline.
Yeah.
In 1959, when Kline moved in, security was tight. 2047 doorman, man desk, the whole deal. By 1966, all of that was gone.
Yeah.
Desk unattended, doors unlocked.
A total downgrade.
A total downgrade. 3, the crime wave. There's a documented increase in assaults and robberies inside the hallways, and the landlord has actual notice. Kline herself warned them. And 4, the incident itself. November 17, 1966, 10:15 p.m., Kline is assaulted and robbed in the common hall right outside her apartment.
And what was the core legal issue?
The issue was whether a duty should be placed on a landlord to take steps to protect tenants from foreseeable criminal acts committed by third parties in the common areas of the building.
So what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court established this rule. A landlord in an urban multiple-dwelling unit owes a duty of reasonable care to protect tenants from predictable criminal acts. And that rule has 3 core elements. First, the logic of control, meaning the landlord is the only party with the power to act. Second, the implied contract, meaning the tenant had a reasonable expectation of security. And third, foreseeability, meaning the landlord had notice of a likely danger.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the logic of control?
Okay, so for the control element, the sub-rule is that duty falls on the one with the power to act. And in applying that, the court found tenants cannot secure common areas. You can't guard the garage or install alarms in the lobby, and the municipal police cannot patrol inside private hallways. So, by process of elimination, the only party with the legal right and physical ability to secure those common areas is the landlord. The conclusion element met. The landlord is the only party with power to minimize risk.
Understood. Now, what about the second element, implied contract and expectation?
Here, the sub-rule is that a tenant is entitled to expect the premises will stay in the condition they were in at the start of the lease. Applying that here. In 1959, security was tight, doorman, attendance, all of it. By 1966, these measures were drastically reduced while rent stayed the same. Kline relied on that 1959 standard. So the court's conclusion element met. The standard of care is measured by the protection provided when the tenancy began.
And the third element, foreseeability.
For foreseeability, the sub-rule is that liability is imposed if violence is probable and predictable, not just possible. And the application here was overwhelming. The record showed a rising wave of crime, specifically in the building's hallways. Another female tenant was attacked in the same way just 2 months prior. The landlord had actual notice. So the conclusion for this element was also clear. Element met. It was almost a certainty that further attacks would occur.
And after analyzing all the elements, what was the court's final conclusion?
The court reversed the lower court's decision. The holding was that the landlord breached the standard of care. The risk was predictable, the landlord had exclusive control, and they failed to maintain the security measures that were implied in the contract. But, and this is key, they also limited it, noting the landlord is not an insurer. They don't guarantee safety, but they must take reasonable steps.
Okay, this has been an incredibly detailed breakdown. Can you distill this all into a tool for our listeners, something they could use?
Absolutely. Think of it as a landlord liability diagnostic checklist. 4 quick questions.
I love a checklist. What's number 1?
First, check the setting. Is this a multi-unit urban dwelling? That's where the innkeeper analogy really kicks in.
Got it. Number 2.
Second, locate the crime. Did it happen in a common area, a hallway, lobby, garage? If yes, the landlord has exclusive control. That's the key.
Right.
Third, test foreseeability. Is there a history of similar crimes on the premises? Look for notice in the fact pattern. Is it probable or just possible.
And the final check.
Number 4, define the standard of care. Look at the security provided at the start of the lease. Has it degraded? The landlord has a duty to maintain that relative level of security. If you can check those 4 boxes, you likely have a Kline situation.
If the landlord has the power to prevent and the knowledge of the danger, the law imposes the duty to act.
That's the bottom line.
So we moved from a world where a landlord was a bystander to crime to a world where they are the first line of defense in the common hallway.
The huge shift.
But I want to leave our listeners with a final thought, because the court actually mentioned this. The cost of all this security, the doormen, the locks, that cost gets passed to tenants in higher rents.
It always does.
So does this ruling, in the name of protecting vulnerable people, actually end up pricing them out of safe housing. It's a real tension, isn't it?
It's the classic trade-off, safety versus affordability. And it's a question the law created, but the market still hasn't really solved.
That is something to chew on. Thanks for diving in with us today.
My pleasure.
Check your locks, know your rights, and we'll see you on the next deep dive.